Welcome back to Legalese 123, where we are covering cases across America. Hello and welcome back to Legalese 123. I'm your host, Missy K. What do we got going on? Well, we are day 15 in the Kouri Richins trial, and it is closing arguments. On Friday, they went through the charging documents to see exactly what elements of the crime that the jury is to consider, talked about jury instructions, etc. It was a long and arduous day. I didn't cover it. I'm sorry. It's okay. It was my birthday. It was Friday, just too long. So, what's going on in the world today? It is the 16th of March. And oh my goodness, if you live anywhere in the middle of the states, wow. Last night was bananas, right? Bananas. You got blizzards going on in the north. You got tornadoes and severe thunderstorms happening all across the middle of the United States, all the way from Texas all the way up to Chicago. And then people who had tornado warnings and what have you started getting blizzards. It was just bananas. So if you watch Ryan Hall, y'all, he is fabulous. He was streaming last night forever. So everybody's safe. Everybody's okay. I hope that you're safe. I hope that you had nothing really terrible happening to you. It is crazy. I also wanted to let you know that I made my scrunchie. That's right. Scrunchies are kind of making a comeback. But I told you I'm a knitting person, and I made a scrunchie. My first scrunchie was made for a certain someone, and then I made one for myself. So I finally did that. That was my birthday present to myself. That's right. All right, so what do we got going on today? We have closing arguments in the Kouri Richins case. What does that mean? Well, remember, closing arguments are not evidence, but it does sort of solidify the case. The prosecution has been very clear in what they are going to present. Motive means opportunity. Kouri herself was a person who pretty much ratted herself out, right? The walk the dog letter, the emails, the text messages, the diary. Are these indications that she committed this crime? It's for the jury to decide, right? But they're going to put all of these elements together in a nice little package, wrap it up in a bow, and say, here you go. Now, more importantly, what is the defense going to do, right? They did not put on a defense. What could they possibly do, right? First of all, they cannot even make a closing statement. They don't have to. The prosecution can go ahead and make a closing statement, and then that's it. The defense doesn't have to do or say anything. Now, in absence of doing that, that would be bonkers, right? But they've done some bonkers things throughout this trial, so you just never know what they're going to do. But in my opinion, if they were to go ahead and do something, they would state, listen, in reference to the attempted breakfast sandwich Valentine's Day attempt, there's no proof of that. They don't know what's in that sandwich. They don't know if it was poisoned. They don't know if Eric had an allergic reaction or not. There's no proof beyond a reasonable doubt. There's no proof of that. Then let's talk about the fentanyl in his system and how he died, right? There was no fentanyl found in the house. The police also failed to do their due diligence in looking in his work trucks. His work trucks were taken away. The police they said that they kind of searched them, but one minute we said somebody was searching it, they don't have a record of searching it. Was there fentanyl in there? Could Eric have accidentally poisoned himself? It's a possibility, right? The insurance fraud, that one's a little tough. The defense is stating that she could have signed his name for him. Kind of a little tough. So it's going to be hard for them to chip away at some things. But just remember, it is not evidence. What the defense says in closing arguments is not evidence. So when will the jury get the case? My thoughts are it's going to be sometime after lunch. Why? Because Judge Mrazek stated that both sides can take as long as they want in closing arguments. Could be forever, right? Hopefully not. The prosecution has been very clear, and they've been very clear about hitting the bullet points and moving on. The The defense, on the other hand, is bumbling around and just stating everything that's on the top of their tongue. Will they be a little bit more organized? So my thoughts are that with all of the closing arguments, the charging documents, and all the elements that the judge has to go over, I'm thinking that they'll get it by lunchtime, perhaps, and then we're on verdict watch, right? And remember, there are 4 elements that she's being charged with: aggravated murder, attempted aggravated murder, insurance fraud at 2 times, and then forgery. Could she be guilty on some and not others? Yes. Can she be acquitted on all of them? Yes. Okay, is there a mistrial? We just don't know what the jury is going to do. So, without further ado, let's just get into it and see what each one of these has to say. All righty tighty, let's go. I got my justice detained.
Counsel for the state are present. Counsel for the defendant are present, along with Ms. Richins. We're set this morning for a closing argument. Mr. Bloodworth, is the state ready to proceed?
Yes, Your Honor.
Ms. Lewis?
We are.
Okay. Anything before we invite the jury in? Mr. Bloodworth?
No, sir.
Ms. Lewis?
Where's Mr. Ramos? Aw. What is Miss Nestor
Okay.
doing? Oh.
Cody, we're ready for the jury. Well,
I don't know who's dressing.
Confirm that we have consensus regarding the exhibits that we're sending back into the jury room.
I don't know who's dressing Kouri
Yes,
Richins.
any physical.
For example, the glassine bags of the gummies, etc.
Correct.
Okay. I wasn't planning to send those back, Ms. Lewis.
That's fine.
Okay. Very good.
Your Honor, is the court sending a computer back for the kind of audio video files? Got it.
We have a air gap computer that will not attach to the internet or connect to the internet, that they'll be able to use to view files off a thumb drive.
Right, Your Honor.
All right, here we go. Court's in session. Day 15 in the Kouri Richins case.
Have a seat. Have a seat.
Jury in.
Then we'll begin this morning with jury instructions. Then we'll take
jury
a
instructions
restroom
first.
break, and then we'll proceed with closing arguments. You have a
All right.
copy of the jury instructions on your chair. You're welcome to read along, but you're not required to. You'll be able to bring those back with you into the jury room to
Here we
review
go.
during your
Jury
deliberations.
instructions.
And we can fast forward to instruction number 13. The preceding pages before instruction 13 are just a written copy of the jury instructions the court gave prior to opening statements. Closing roadmap. Members of the jury, you now have all the evidence. 3 things remain to be done. First, I'll give you additional instructions that you will follow in deciding this case. Second, the lawyers will give their closing arguments. Prosecutor will go first, then the defense. Because the prosecution has the burden of proof, the prosecutor may give a rebuttal. Finally, you will go to the jury room to discuss and decide the case. You have 2 main duties as jurors. The first is to decide from the evidence what the facts are. Deciding what the facts are is your job, not mine. You are the exclusive judges of all questions of fact. The second duty is to take the law I give you in the instructions, apply it to the facts, and decide if the prosecution has proved the defendant guilty beyond a reasonable doubt. You are bound by your oath to follow the instructions that I give you, even if you personally disagree with them. This includes the instructions I gave you before trial any instructions I may have given you during the trial, and these instructions. All the instructions are important, and you should consider them as a whole. The order in which the instructions are given does not mean that some instructions are more important than others. Whether any particular instruction applies may depend upon what you decide are the true facts of the case. If an instruction applies only to facts or circumstances that you find do not exist, you may disregard that instruction. Please perform your duties fairly. Do not let any bias, sympathy, or prejudice that you may feel toward one side or the other influence your decision in any way. You must also not let yourselves be influenced by public opinion. Regarding closing arguments, when the lawyers give their closing arguments, please keep in mind that they are advocating their views of the case. What they say during their closing arguments is not evidence. If the lawyers say anything about the evidence that conflicts with what you remember, you are to rely on your memory of the evidence. If they say anything about the law that conflicts with these instructions, you are to rely on these instructions. During the trial, I've made certain rulings. I made those rulings based on the law and not because I favor one side or the other. However, if I sustained an objection, if I did not accept evidence offered by one side or the other, or if I ordered that certain testimony be stricken, then you must not consider those things in reaching your verdict. As the judge, I am neutral. If I have said or done anything that makes you think I favor one side or the other, that was not my intention. Please do not interpret anything I've done as indicating that I have any particular view of the evidence or the decision you should reach. You must base your decision only on the evidence that you saw and heard here in court. Evidence includes what the witnesses said while they were testifying under oath and any exhibits admitted into evidence. Nothing else is evidence. The lawyer's statements and arguments are not evidence. Their objections are not evidence. My legal rulings and comments are not evidence. In reaching a verdict, consider all the evidence as I have defined it here and nothing else. You may also draw all reasonable inferences from that evidence. Regarding items not admitted into evidence, transcripts, police reports, or other written audio or visual materials may have been referenced during the trial but not admitted as exhibits. It's common during deliberations for jurors to ask to review these materials or to have transcripts of what witnesses said during trial. These materials, other than what may have been admitted as exhibits, may not be requested as part of your deliberations. Regarding witness credibility, in deciding this case, you'll need to decide how believable each witness was. Please use your judgment and common sense. Let me suggest a few things to think about as you weigh each witness's testimony. How good was the witness's opportunity to see, hear, or otherwise observe what the witness testified about? Does the witness have something to gain or lose from this case? Does the witness have any connection to the people involved in this case? Does the witness have any reason to lie or slant the testimony? Was the witness's testimony consistent over time? If not, is there a good reason for the inconsistency? If the witness was inconsistent, was it about something important or unimportant? How believable was the witness's testimony in light of other evidence presented at trial? How believable was the witness's testimony in light of human experience? Was there anything about the way the witness testified that made the testimony more or less believable? In deciding whether or not to believe a witness, you may also consider anything else you think is important. You do not have to believe everything that a witness said. You may believe part and disbelieve the rest. On the other hand, if you're convinced that a witness lied, you may disbelieve anything the witness said. In other words, you may believe all, part, or none of a witness's testimony. You may believe many witnesses against one, or one witness against many. In deciding whether a witness testified truthfully, please remember that no one's memory is perfect. Anyone can make an honest mistake. Honest people may remember the same event differently. Evidence has been presented that a witness was previously convicted of a crime. This evidence was brought to your attention only to help you evaluate the credibility of that witness. Do not use it for any other purpose. It is not evidence of anything else. An informant is someone who provides evidence against someone else for a personal reason or advantage. The testimony of an informant alone, if believed by the jury, may be of sufficient weight to sustain a verdict of guilt, even though not corroborated or supported by other evidence. You must examine and weigh an informant's testimony with greater care than the testimony of an ordinary witness. You must determine whether the informant's testimony has been affected by self-interest, by an agreement they have with the government, by their own interest in the outcome of the case, or by prejudice against the defendant. You should not convict a defendant based on the unsupported testimony of an informant unless you believe the unsupported testimony beyond a reasonable doubt. A person may testify under a grant of immunity, that is, an agreement with the government. Their testimony alone, if believed by the jury, may be of sufficient weight to sustain a verdict of guilt, even though it's not corroborated or supported by other evidence. You should consider testimony given under a grant of immunity with greater care and caution than the testimony of an ordinary witness. You should consider whether testimony under a grant of immunity has been affected by the witness's own interest, the government's agreement, the witness's interest in the outcome of the case, or by prejudice against the defendant. On the other hand, you should also consider that an immunized witness can be prosecuted for perjury for making a false statement. After considering these things, you may give testimony given under a grant of immunity such weight as you feel it deserves. You should not convict a defendant based on the unsupported testimony of an immunized witness unless you believe the unsupported testimony beyond a reasonable doubt. Remember, the fact that the defendant is charged with a crime is not evidence of guilt. The law presumes that the defendant is not guilty of the crime charged. This presumption persists unless the prosecution's evidence convinces you beyond a reasonable doubt that the defendant is guilty. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every possible doubt. If the evidence leaves you firmly convinced that the defendant is guilty of the crime charged, you must find the defendant guilty. On the other hand, if there is a real possibility that she is not guilty, you must give the defendant the benefit of the doubt and return a verdict of not guilty. The defendant has entered a plea of not guilty and denies committing the alleged crimes. Every crime has component parts called elements. The prosecution must prove each element beyond a reasonable doubt. Until then, you must presume the defendant is not guilty. The defendant does not have to prove anything. She does not have to testify, call witnesses, or present evidence. Regarding direct and circumstantial evidence, facts may be proved by direct or circumstantial evidence. The law does not treat one type of evidence as better than the other. Direct evidence can prove a fact by itself. It usually comes from a witness who perceived firsthand the fact in question. For example, if a witness testified that he looked outside, saw it was raining, that would be direct evidence that it had rained. Circumstantial evidence is indirect evidence. It usually comes from a witness who perceived a set of related events, but not the fact in question. However, based on that testimony, someone could conclude that the fact in question had occurred. For example, if a witness testified that she looked outside and saw that the ground was wet and people were closing their umbrellas, that would be circumstantial evidence that it had rained. Before you can find the defendant guilty of any charge, there must be enough evidence, direct, circumstantial, or some of both, to convince you of the defendant's guilt beyond a reasonable doubt. It is up to you to decide. You have heard evidence that before or after the alleged acts charged in this case, the defendant may have done the following: made false statements connected to the financial affairs of her business, engaged in an extramarital affair, or made false claims about whether she was the sole author of a book. This evidence was not admitted to prove a character trait of the defendant or to show that she acted in a manner consistent with that trait. You may consider this evidence, if at all, for the limited purposes of determining motive, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. Keep in mind that the defendant is on trial for the crimes charged in this case, and for those crimes only. You may not convict the defendant simply because you believe she may have committed some other acts at another time. Regarding fact versus expert witnesses, there are two types of witnesses: fact witnesses and expert witnesses. Usually, a fact witness can testify only about facts that he or she can see, hear, touch, taste, or smell. An expert witness has scientific, technical, or other special knowledge that allows the witness to give an opinion. An expert's knowledge can come from training, education, experience, or skill. Experts can testify about facts, and they can give their opinions in their area of expertise. You may have to weigh one expert's opinion against another's. In weighing the opinions of experts, you may look at their qualifications, the reasoning process the experts used, and the overall credibility of their testimony. You may also look at things like bias, consistency, and reputation. Please use your common sense in evaluating all witnesses, including expert witnesses. You do not have to accept an expert's opinion. You may accept it all, reject it all, or accept part and reject part. Give it whatever weight you think it deserves. You have heard the testimony of law enforcement officers. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. It is up to you to give any witness's testimony whatever weight you think it deserves. Regarding the defendant not testifying, a person accused of a crime may choose whether or not to testify. In this case, the defendant chose not to testify. Do not hold that choice against the defendant. Do not try to guess why the defendant chose not to testify. Do not consider it in your deliberations. Decide the case only on the basis of the evidence. The defendant does not have to prove that she is not guilty. The prosecution must prove the defendant's guilt beyond a reasonable doubt. Regarding conduct and mental state, a person cannot be found guilty of a criminal offense unless that person's conduct is prohibited by law and, at the time the conduct occurred, the defendant demonstrated a particular mental state specified by law. Conduct can mean both an act or the failure to act when the law requires a person to act. An act is a voluntary movement of the body, and it can include speech. As to the mental state requirement, the prosecution must prove that at the time the defendant acted, she did so with a particular mental state. For each offense, the law defines what kind of mental state the defendant had to have, if any. For some crimes, the defendant must have acted intentionally or knowingly. For other crimes, it's enough that the defendant acted recklessly or with criminal negligence or with some other specified mental state. Later, I'll instruct you on the specific conduct and mental state that the prosecution must prove before the defendant can be found guilty of the crimes charged. The law requires that the prosecutor prove beyond a reasonable doubt that the defendant acted with a particular mental state. Ordinarily, there is no way that a defendant's mental state can be proved directly because no one can tell what another person is thinking. A defendant's mental state can be proved indirectly from the surrounding facts and circumstances. This includes things like what the defendant said, what the defendant did, and any other evidence that shows what was in the defendant's mind. Some definitions. On or about includes any day that is near the day alleged in the information. For pecuniary gain means for the acquisition of money or something of monetary value. Attempt means the actor engages in conduct that constitutes a substantial step toward the commission of the crime and intends to commit the crime, or when causing a particular result is an element of the crime, acts with an awareness that her conduct is reasonably certain to cause the result. Conduct constitutes a substantial step toward the commission of the crime when it strongly corroborates the actor's required mental state to commit the crime. Utter means any intentional act that puts a writing into circulation and implies, by word or action, that the writing is genuine. Unless these instructions give a definition, you should give all words their usual and ordinary meanings. Elements of count 1, criminal homicide, aggravated murder. Kouri Richins is charged in count 1 with committing aggravated murder between on or about March 3rd and March 4th, 2022. You cannot convict her of this offense unless, based on the evidence, you unanimously find, beyond a reasonable doubt, each of the following elements. Kouri Richins intentionally or knowingly caused the death of Eric Richins under one or more of the following circumstances: for pecuniary gain or by means of the administration of any substance administered in a lethal amount, dosage, or quantity. After you carefully consider all the evidence in this case, if you are convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant guilty. On the other hand, if you are not convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant not guilty. To find the defendant guilty of aggravated murder, you must unanimously agree the prosecution has proven at least one circumstance listed in element 3 beyond a reasonable doubt. You must also unanimously agree which circumstance or circumstances the prosecution has proven. You will mark your decisions on the verdict form. Elements of count 2, attempted criminal homicide, attempted aggravated murder. Kouri Richins is charged in count 2 with committing attempted aggravated murder on or about February 14, 2022. You cannot convict her of this offense unless, based on the evidence, you unanimously find, beyond a reasonable doubt, each of the following elements. Kouri Richins attempted to intentionally or knowingly cause the death of Eric Richins under one or more of the following circumstances: for pecuniary gain or by means of the administration of any substance administered in a lethal amount, dosage, or quantity. After you carefully consider all the evidence in this case, if you are convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant guilty. On the other hand, if you are not convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant not guilty. To find the defendant guilty of attempted aggravated murder, you must unanimously agree the prosecution has proven at least one circumstance listed in element 4 beyond a reasonable doubt. You must also unanimously agree which circumstance or circumstances the prosecution has proven. You will mark your decisions on the verdict form. Definitions of mental state related to counts 1 and 2. For the purposes of counts 1 and 2, a person acts intentionally or with intent when her conscious objective is to cause a certain result. A person acts knowingly or with knowledge when the person is aware that her conduct is reasonably certain to cause a particular result. Elements of count 3, insurance fraud. Kouri Richins is charged in count 3 with committing insurance fraud between on or about January 29 and August 31 of 2022. You cannot convict her of this offense unless, based on the evidence, you unanimously find beyond a reasonable doubt each of the following elements. Kouri Richins, with intent to deceive or defraud, intentionally, knowingly, or recklessly devised a scheme or artifice to obtain anything of value by means of false or fraudulent pretenses, representations, promises, or material omissions, and the value of the property, money, or things obtained or sought to be obtained is or exceeds $5,000. After you carefully consider all the evidence in this case, if you are convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant guilty. On the other hand, if you're not convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant not guilty. Elements of count 4, insurance fraud. Kouri Richins is charged in count 4 with committing insurance fraud on or about June 14, 2022. You cannot convict her of this offense unless, based on the evidence, you unanimously find, beyond a reasonable doubt, each of the following elements. Kouri Richins, with intent to deceive or defraud, presented or caused to be presented any oral or written statement or representation as part of or in support of a claim for payment or other benefit pursuant to an insurance policy, certificate, or contract. Knowing that the statement or representation contained false, incomplete, or fraudulent information concerning any fact or thing material to the claim, and the value of the property, money, or things obtained or sought to be obtained is or exceeds $5,000. After you carefully consider all the evidence in this case, if you are convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant guilty. On the other hand, if you're not convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant not guilty. Elements of count 5, forgery. Kouri Richins is charged in count 5 with committing forgery on or about January 29, 2022. You cannot convict her of this offense unless, based on the evidence, you unanimously find beyond a reasonable doubt each of the following elements. Kouri Richins, with purpose to defraud anyone without the authority to do so, did make, execute, or utter a writing so that the writing or the making, execution, or utterance purports to be the act of another person. After you carefully consider all the evidence in this case, if you're convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant guilty. On the other hand, if you're not convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant not guilty. Definitions of mental state for counts 3, 4, and 5. For purposes of counts 3, 4, and 5, a person acts intentionally or with intent when her conscious objective is to engage in certain conduct. A person acts knowingly or with knowledge when the person is aware of the nature of her conduct, or is aware of the particular circumstances surrounding her conduct, or is aware that her conduct is reasonably certain to cause a particular result. A person acts recklessly when she is aware of a substantial and unjustifiable risk that certain circumstances exist relating to her conduct, but she consciously disregards the risk and acts anyway. Or her conduct will cause a particular result, but she consciously disregards the risk and acts anyway. The nature and extent of the risk must be of such a magnitude that disregarding it is a gross deviation from what an ordinary person would do in that situation. Conduct means either an act or an omission. Separate consideration of multiple crimes. The defendant has been charged with more than one crime. It is your duty to consider each charge separately. For each crime charged, consider all the evidence related to that charge. Decide whether the prosecution has presented proof beyond a reasonable doubt that the defendant is guilty of that particular crime. Your verdict on one charge does not determine your verdict on any other charge. Regarding jury unanimity. Because this is a criminal case, every single juror must agree with the verdict before the defendant can be found guilty or not guilty. That is, you must be unanimous in your verdict for each count charged. To help you in reaching unanimity.
So I like how he separated that out. He said that each crime is separately. You're to consider each one separately. And the reason why this is very important is because in the Karen Reed case, in the very first one that she was had a mistrial, the jury form was so obnoxious, and they were unable to say they were the way that it was stated was that you had to it was all or nothing on each one of them, and they did not know what to do. They asked for clarification, and they were not given any clarification. So the defense even said in the beginning, "Hey, judge, this jury form is unclear. And she's like, nope, it's all good. And so therefore it was a big cluster, you know what. When they tried her again, because of course they did, it was much clearer. And again, we know that she was acquitted of charges except for the DUI.
Unanimous agreement, I recommend that you not commit yourselves to a particular verdict before discussing all the evidence. In addition, you may not use methods of chance, such as drawing straws or flipping a coin. Rather, in the jury room, please consider the evidence and speak your minds with each other. Listen carefully and respectfully to each other's views, and keep an open mind about what others have to say. If there is a difference of opinion about the evidence or the verdict, do not hesitate to change your mind if you become convinced that your position is wrong. On the other hand, do not give up your honestly held views about the evidence simply to agree on a verdict, to give in to pressure from other jurors, or just to get the case over with. In the end, your vote must be your own. A unanimous verdict must reflect the individual, careful, and conscientious judgment of each juror as to whether the defendant is guilty or not guilty. In making your decision, do not consider what punishment could result from a verdict of guilty. Your duty is to decide if the defendant is guilty beyond a reasonable doubt. Punishment is not relevant to whether the defendant is guilty or not guilty. Let's pause there for now. That went a little quicker than I anticipated. Mr. Bloodworth, would you like to proceed?
Yes, Your Honor, we may proceed and then maybe take an intermission.
Understood.
All right, folks, here we go.
No problem.
We're going to go back to the 1-point speed because Mr. Bloodworth is going to give us everything.
Yes, Your Honor, please.
There you are. Please proceed.
Thank you. Kouri Richins feels aggrieved and is thus an intensely ambitious person. She feels aggrieved because growing up, her father was an alcoholic who traded parenting for prison, and her mother a gambler who traded parenting for a casino. Kouri Richins thus worked for her aunt, cleaning the homes of rich people in Park City. She was not beneath those homeowners, but she felt that she was. This fueled in her an intense desire to appear privileged, affluent, and successful. She met Eric Richins. He was a successful business owner. He had money. They had a son, married, and had 2 more sons. Kouri Richins was on her way. But she was unhappy. She wanted to leave Eric Richins, but did not want to leave his money. Their prenuptial agreement meant that if she left him, she would also leave most of his money. So, Kouri Richins took $250,000 in equity out of Eric Richins' home without him knowing it, so that she could start her own business and earn enough money to leave Eric Richins. Kouri Richins is intensely ambitious. First with Eric's money and then other people's money, Kouri Richins carefully curated the facade of a privileged, affluent, successful business owner. Behind the facade, however, Kouri Richins was incompetent. She took tremendous risks. She borrowed money by any means necessary at exorbitant rates. She gambled other people's money and lost. Her business was imploding. All the while, Kouri Richins was more interested in spending time with Josh Grossman than Eric. She dreamed of living in the Midway Mansion with Josh, running it as an event center, farming and raising kids. Eric's kids. But she did not have the money to leave Eric or the money to salvage her business. Kouri Richins is an intensely ambitious person. She is a risk taker. There was a way forward. Eric had to die. As Judge Mrazek just instructed, there are 5 counts. And each count has a series of elements. The state has to prove each count and each element of each count beyond a reasonable doubt. That is our burden. In this closing, we will go count by count, and then within each count, element by element, to show to you how the state has met its burden of proving aggravated murder, attempted aggravated murder, 2 counts of fraud, and forgery. That, again, is the reasonable doubt instruction that Judge Mrazek just read, and you will have back with you in the jury room. Judge Mrazek also read this instruction on what evidence is, and it's usually testimony and exhibits. To reiterate, what the attorneys say is not evidence. And as I asked you in opening, please focus on the evidence. Throughout this presentation, I generally use this format for slides. And so everybody understands where we are, the count, and then the element within the count is at the top in the red banner. We then quote some witness testimony and we cite it because it's the evidence that matters. So that you have, you'll have the exhibits back with you when you deliberate.
Right.
And you can reference them. Usually it's a transcript.
Remember, what they say is not evidence, but boy, they're going to lay it out. I told you, the prosecution is going to be concise.
Page, line,
And
number.
here's receipts, timelines, etc.
We also publish exhibits. And usually we'll have an exhibit number down here. If there's an exhibit, whatever, 2-5, so you can reference it. Let's begin with the aggravated murder count.
Lay it
The
out
evidence
for
will
you.
prove that
you
Kouri
go.
Richins
Serve it on a platter.
was the person who committed the aggravated murder.
Pecuniary
The evidence will
gain.
prove that she intentionally or knowingly caused the death of Eric Richins, here by means of administering to him the illicit street drugs that she purchased from Carmen Lauber. She intended to kill him with the illicit street drugs. It doesn't matter what illicit street drugs. We'll get into it more. It doesn't matter if it was the propofol, if it was the fentanyl that actually killed him, if it was oxy or some other illicit street drugs. She bought illicit street drugs to kill Eric Richins. That's what matters. That's murder. These 2 elements are just murder.
I also wonder if they're going to talk about the quetiapine that was in her name. Wonder if that's going to come up.
Right? If we hide this, that's a murder charge. Here we have an aggravated murder charge, and the state will prove 2 separate and distinct aggravators. The first is for pecuniary gain. This is a why aggravator. Why did Kouri Richins kill Eric? for money. The second aggravator is a how aggravator. How did she do it? Here, by the administration of any substance, here it happens to be fentanyl, but it could be any substance administered in a lethal amount. Either one of those aggravators are what transforms this case from a murder case to an aggravated murder case. So, first element, was it Kouri Richins? Yes. The state has proved that Kouri Richins had the means, here the fentanyl, the illicit street drugs, the motive, here money, and a fresh start at life, and the opportunity to kill Eric Richins. She was the only other adult in the home at the time. Nobody else killed Eric Richins. Now, intentionally or knowingly caused the death of Eric Richins by administering the illicit street drugs. The state will prove with all kinds of evidence, testimony, exhibits, patterns of her behavior, and what each of us know about humans, that she intended to cause Eric's death. She intended it probably as early as December the 7th, 2021, when she booked a trip for her and Josh Grossman to the Caribbean for April. People don't book that trip. Kouri Richins did not book that trip thinking Eric Richins would be alive in April. She booked it knowing he would not.
I wholeheartedly agree with that, right? Because how else is she going to then say, okay, Eric, I'm leaving. I'm leaving to go be with my boyfriend in April. Of course, she's not going to say that. But if he was still alive, what would she have said? It's a girl's trip, whatever. I'm sure she would have lied. I mean, obviously she has to. Right. Book that knowing that he wasn't going to be alive.
In December, before Eric died, before Kouri Richins murdered Eric, she told her friend, Becky Lloyd, in many ways it would be better if he were dead.
Right.
That proves she intended to cause his death. This was the New York Life policy that covered the C&E buy-sell agreement. And on January the 1st, 2022, Kouri Richins changed the life insurance beneficiary on Cody's policy from Eric to her. The evidence proves that Kouri Richins didn't understand that was Cody's policy. And when she figured it out, she went ahead and changed it back because she planned to murder Eric. She did not plan to murder Cody, but
Right.
she planned to murder. Kouri Richins asked two people, Hayden Jeffs and Carmen Lauber, for the Michael Jackson drug. Kouri Richins was a suburban mother real estate agent. She does not know a lot about the illicit street drug world, but she knows Michael Jackson died from taking drugs. She doesn't know how to order a street drug, but she knows she wants the Michael Jackson stuff. She knows she wants it because it is lethal, it is fatal, it kills. And she wanted lethal, fatal death. Kouri Richins is intensely ambitious. She wanted the perfect life, or at least the appearance of the perfect life. And for her, that meant Josh Grossman. But first, Eric had to go away.
So with these transactions, when Carmen hit you up, what did she tell you?
She just told me that she had a friend that wanted, you know.
Did she ask for blue specifically or fentanyl specifically, or did she ask for oxygen? What did she ask for?
No. I think she might have asked me for blue. I can't remember.
But you sold her M30, right?
Yeah, I told her what she knew what she was buying.
Okay, so it wasn't like she's asking for oxys or something like that. She got the M30.
Right, no.
Okay. She knew that there was fentanyl in this pill.
Absolutely.
At Kouri Richins' request, Carmen Lauber purchased illicit street drugs from Robert Crozier. It's those illicit street drugs that killed Eric Richins. It's those illicit street drugs that Kouri used to murder Eric Richins. And while there may be some question as to whether she specifically ordered fentanyl or she knew she was getting fentanyl, the evidence proves she at least knew it. She wanted fatal, lethal, illicit street drugs. And all the testimony from Carmen Lauber, Robert Crozier, digital forensics, we'll get into it, all confirm that Kouri Richins ordered and received illicit street drugs, and that those street drugs contained fentanyl. Is all that matters.
Jumped.
But you heard the testimony that despite confusion in what people were ordering, people were getting fentanyl. The fake M30s looked like the real, the fake M30s looked like the real M30s. Everything on the street in early 2022 had fentanyl. That's how we know that it was this purchase that ended up killing Eric. It's the fentanyl. We can trace the fentanyl. Next slide. The digital forensics corroborate Carmen Lauber's testimony that 5 days before Kouri Richins murdered Eric Richins, Carmen Lauber purchased for Kouri Richins fentanyl from Robert Crozier at the Maverick in Draper. The call detail records show an extraordinary amount of overlapping communication between Carmen Lauber, Kouri Richins, Carmen Lauber, Robert Crozier during that time. We, of course, don't have the communications. Carmen Lauber deleted them because they were evidence of a drug deal. Kouri Richins deleted them because they were evidence of a drug deal and a murder. Robert Crozier said he had lost his phone. But that's an extraordinary number of communications. We know that Kouri Richins, the evidence proves that Kouri Richins used a Moscow Mule and a shot to administer the fentanyl to Eric. She writes it in her orange notebook where she journals what happened the night she murdered Eric. It's a self-serving journal. We'll discuss that down the road. But she wrote Moscow Mule and a lemon drop shot. And that is consistent with all the toxicology.
Beg to differ a little bit about that because he couldn't say what kind of alcohol he had in the system.
Again, in
but-
the notes that investigators
He had a boatload of
recovered from the
fentanyl in his
kitchen
system.
cabinet in Kouri Richins' home, she wrote Moscow mules.
Right.
Lemon water,
Wrote it again.
vodka, and rum. She left out the main ingredient, which of course is the ginger beer. But there was ginger beer. We know that from the Cock and Bull that OME investigator Cam Sessions found in the trash can in the kitchen. It's interesting that Kouri Richins wrote vodka in parentheses rum. The evidence may show that the Moscow meal she made that night was ginger beer and fentanyl. The lemon drop shot may be lemon and fentanyl. Notice that here she writes drink in bed. We'll come back to that in a minute.
Yeah, drink in bed. I wanted to know what that was too.
The Cock and Bull, as I mentioned, corroborates at least the Moscow Mule. And then we know the cause of death from the death certificate was fentanyl. The fentanyl and the illicit street drugs that Kouri Richins got from Carmen Lauber, who got from Robert Crozier. We know that Eric ingested the fentanyl from the Moscow Mule, the lemon drop shop, or both. Medical examiner Dr. Pamela Ulmer, toxicologist Brianna Peterson, chief medical examiner Dr. Eric Christensen, all testified that the 20,000 nanograms per milliliter of fentanyl, an extraordinary amount, in his stomach indicates oral ingestion. Indeed, Dr. Christensen not only testified to it, he told Kouri Richins that in their phone call that she recorded.
Why is she recording phone calls? Girl.
Ms. Peterson's testimony, as well as Dr. Christensen, also proves that the fentanyl was illicit. Again, illicit coming from the street, illegal street drug, illicit fentanyl. And it was their testimony, right, was that there was not only fentanyl in the toxicology, but there was norfentanyl, which was a marker of an illicit fentanyl. There's also acetyl fentanyl as well. But it's the norfentanyl that is a marker of illicit fentanyl, which completely tracks with how Kouri Richins got the illicit street drugs. We also know that Kouri Richins
Knew it. Quetiapine.
intended to kill Eric Richins because the toxicology contained quetiapine.
Knew it.
Your Honor, we may have lost audio. Let's reset. My apologies.
I knew the quetiapine was going to come in. And what is he going to say about it? Because why would he take quetiapine? What was she?
Antipsychotic medication.
Last one. What is quetiapine? Quetiapine?
Yep.
Quetiapine is an antipsychotic medication. It's called Seroquel.
Okay.
It's a prescription, mental health medication
Mhm.
that's prescribed for different things.
I got you.
The quetiapine in the toxicology for Eric Richins shows that Kouri Richins was involved because she was prescribed
Yep.
quetiapine.
I knew that was going to
This
come.
conversation that she recorded with Dr. Christensen is also very insightful. She pretends to not know what quetiapine is. It's her prescription. Of course she
Right.
knows what it is. She pretends to not know what it is to cover up her involvement in putting the quetiapine inside Eric's body. She feigns the ignorance. She covers up her conduct in murdering Eric Richins in several ways throughout, beginning the night she murdered him, all the way through the walk the dog letter. In the orange notebook, she writes, she jumped out of bed, ran, turned on the lights, grabbed her phone, and called 911. The evidence proves that is not true. The evidence proves that when she returned to their bedroom, Kouri Richins says she was in Ashton's room. There's no evidence of that. But she returned from somewhere to their bedroom, unlocked her phone, put it on speaker. There's no call detail records showing a call at that time. But she may have called on Wi-Fi, somebody. That would not appear in the call detail records. It would appear on her phone if her phone had not been deleted.
Objection, Your Honor. These are facts that are
Overruled.
not.
Please have a seat.
She then unlocked her phone again at 3:08, 3:10,
Oh,
3:15,
Judge said, sit down.
3:19, 3:19. And then 15 minutes later, she called 911. That is not immediately called 911. Perhaps she was staging the scene during these 15 minutes. We're going to discuss the 911 call in a minute. This is a receiver activation. At 3:22:12, when we're in the 911 call, she's on receiver on her phone. The 911 call operator asks her, are you on speakerphone? She says yes, no. She's on receiver. Before we play this, sorry. We're going to listen to the first part, actually most of the 911 call again. I ask that as you listen to it, you'll hear the first minute. The first minute is not the sound of a wife becoming a widow. To echo her friend Chelsea Barney, the first minute is the sound of a wife becoming a Black widow. Listen to how Kouri Richins on the 911 call immediately presents, very soon after the call begins, presents her alibi narrative. Listen to how she tells the 911 dispatcher where she was when Eric died. She is distancing herself. Rather than, he's not breathing, he has no pulse, I have to figure out what to do, I need help. She's saying, hey, look, I was not there, I was in my son's room. That's her alibi. She's distancing herself from the time and the place that she murdered Eric.
Isn't that very telling, right? Right? When you listen to the 911 calls, we talked about it in the Brendan Banfield trial as well. You're not like, oh my God, oh my God, oh my God, something's happening, what's happening? And you're trying to figure out what happened and the who, what, where, when, how, and why. And your words matter, right? She's explaining something else other than, I need to help my husband. Good catch, prosecution. Good catch. Oh, Kouri, stop with the
911 call
faces.
operator asks her to perform CPR. Notice how she distances herself from that. No, I don't know how. No, he's too heavy. No, I can't move him. She is not immediately trying to revive him.
Right. If you're a caring person and it's someone that you love, you'll do whatever it takes to revive them or give them CPR or whatever the circumstances are. I can't do that. I can't do that. I can't do that.
We're going to run a clock from the time that the dispatcher asks her if she can start CPR to the time she purportedly starts it. It's 6 minutes. Listen, please, to the portion of the 911 call where the operator instructs Kouri Richins how to remove Eric from the bed.
Oh, boy.
Listen how the dispatcher says, move to the side of the bed. Kouri Richins says she does. Remove the pillows, pull the arm, pull the leg, lift up the sheet, pull him off. If Kouri Richins is following the instructions of the 911 dispatcher, Eric Richins' body is on the floor on the side of the bed, not the foot of the bed where it was found. Listen also to her choice of language. She has dehumanized Eric Richins. When she is talking about removing Eric from the bed and she is protesting and she is saying she cannot, she is not saying, I can't move him. She is saying, I can't move it. Eric is no longer a him to him. She murdered Eric. Eric is an it. Finally, listen to when she says she is performing CPR and the phone is on speaker. The phone's not on speaker. Determine whether she's performing CPR. Okay, Scott.
My husband's not breathing. He's cold. Okay, what's the address? 282 Willow Court. 282 Willow Court? Uh-huh. Okay, what's a good phone number in case we get disconnected? 435 671 4987. Okay, it's going to be in Francis. Okay, tell me exactly what happened. I don't know. I was sleeping with my kids. Okay, I can't understand you. I need you to take a deep breath. What's going on? I don't know. I was sleeping in with my kids. I just came in our bed, and I turned over, and he's just cold. He's just cold. Who's cold? My husband. I turned the light off. And he's not breathing? He's not breathing? I need you to confirm it for me. Is he not breathing? No. Okay, can you do CPR? No, I don't know how. You don't know? I'm going to tell you how to. Are you willing to do CPR? Yeah. Okay. If there's a defibrillator available, send someone to get it now and tell me when you have it. No, thank God. Available? Okay. I'm sending the paramedics to help you now. Stay on the line and I'll tell you exactly what to do next, okay? Okay, are you right by your husband right now? Yeah, he's so pale. His mouth is okay. Okay, listen carefully. Are you able to lay him on the floor or the ground? On the ground? I'm just shaking. I can't touch him. I can't. You can do it. You can do it. I can guide you through CPR. Take a deep breath from me. I'm here with you. He doesn't have a pulse. He doesn't have a pulse. No. There's no pulse. Okay, I'm here with you. I'm here with you. We need to get him help. If you need to put me on speaker, put me on speaker. I'm gonna guide you through CPR, okay? Okay. Tell me when you've done that. Okay, I'm ready. You're ready? Okay, he's on the floor? He's on the bed. Okay, are you able by any chance to move him on the floor? Okay. Spots on it. I don't know what's happening. Okay. I'm here with you. You're not able to move him to the floor. Go up. Don't come in here. Oh my God, my sister. You're not able to move him to the floor? Just listen carefully. We just need to get him on the floor. Don't worry about hurting them. No, he's just too heavy. Is he still on the bed? Okay, if there's a sheet or a blanket under them, can you loosen it from the mattress? Yes. Okay, stand at the side of the bed closest to them and remove anything under their head. Okay. Okay. I need you to pull the sheets towards you and slide them off the bed. Don't worry about him falling. We just need to help him now. Okay. Tell me when he's on the floor. I can't move it. It's a dead weight. Like you're not. If he has sheets under, pull them to the floor. Don't worry about hurting him. Can you please send somebody? Okay, I have the ambulance that's on the way. Okay, there's another way to do this. Okay, grab their feet. Grab his feet. Slide them towards you until they're just off the bed.
Ooh, the judge's face. Ugh, he's giving face.
How old is your husband?
39.
39?
Yeah.
Okay. Okay, were you able to pull his feet off the bed?
I'm pulling.
Okay, now grab the arm closest to you and pull the rest of the way off the bed. Again, don't worry about the fall. We just need to help them now. I have the ambulance on the way. I just need you to do this, okay, so we can get the help for him.
Okay.
Once they arrive, they'll take over. We just need to start CPR now. You are doing great, okay? I just need you to get him on the floor.
Okay, on the floor.
You got him on the floor?
Yeah.
Okay, listen carefully, okay? Make sure that there's nothing under his head. Is he laying flat on his back?
Yeah.
Okay. Okay, just listen carefully and I'll tell you how to do chest compressions, okay? Place the heel of your hand on the breastbone. This is in the center of the chest, right between the nipples.
Okay.
Put your other hand on top of that hand.
Okay.
Okay? Stop pumping the chest hard and fast at least twice per second and 2 inches deep.
Okay.
Okay, start counting out loud so I can count with you, okay? We're gonna count 1, 2, 3, 4, okay? Let me know when you're ready.
1,
1, 2, 3, 4. One, 2, 3, 4. Count out loud so I can hear you. I'm counting with you. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3.
She's not
4.
even counting.
1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. 1. If it's easier for you, am I on speaker?
yes.
Okay. 1, 2, 3, 4. Do you know the front door is open?
No, it's locked.
Are you? I need you to go. Is there anybody else within the home or is it just you?
It's all my kids.
Okay. Are one of them old enough to go and lock the door?
Yeah, it's unlocked.
It's unlocked now?
Yeah, he's here. He's there.
Okay.
The protesting. It was part of the 6-minute delay in Kouri Richins performing CPR. I can't move it. It is just dead weight. Contrast that 911 call with her self-serving text message to her best friend, Chelsea Barney. I tried so fucking hard to save him, his lifeless body on my bedroom floor. I pumped so damn hard, so hard, screaming at him to come back to life, that I needed him. None of that happened. She's covering up her involvement in murdering Eric Richins. Recall the alibi narrative at the beginning of the 911 call. Her letting the 911 operator and everyone know that she was not with Eric when he died. I was somewhere else. I was distant in place and time. When she calls her father-in-law, Eric's dad, Gene Richins, what does she say right at the outset? I was sleeping with Ashley and I came into the room. Gene, I wasn't there. Wasn't me. When Eric's sister Katie arrives, he wasn't breathing. I went to bed. I was in Ashton's room. He was having nightmares. I wasn't there. It was not me. Her alibi. Her cover-up. This is the written form that sheriff's deputies gave Kouri Richins early morning of March 4th to write out what happened. It says, describe in detail what you saw. No.
Eric and I put the kids to bed around 9 p.m. We had a drink around 9:15 to celebrate work, brushed our teeth around 9:30. We laid in bed for about 5 minutes. My son was having nightmares, so I went to sleep in his bed. My husband and I said, "Good night, I love you."
Or heard of the incident. Where did she start? Eric and I put the kids to bed around 9 p.m. We had a drink. In Kouri Richins' mind, that's when the incident started. It was the drink, and she knew it because she put the fentanyl in the drink. She didn't start with, I walked into the bedroom at 3 a.m. My husband was not breathing and cold. Describe the incident. The incident for her begins around 9:15 when she has the drink, because she knows that is in fact when the incident began. And then more of her self-serving alibi narrative. It wasn't me, I wasn't there, before she gets into really what matters. Intentionally or knowingly caused the death of Eric Richins. We know it was intentional because she planned the immediate reaction. When she spoke with Eric's sister, Katie, very shortly after, medical examiners rolled Eric Richins' body out of his home for the last time. She told Katie that she was going to plan the Midway, she was going to follow through with the purchase of the Midway mansion. She was going to sell the home that she was living in. And she had a plan for running Eric's business, C&E. The morning of Eric's death. She had those plans in place because she knew she was going to murder Eric. She had already thought about not only murdering him, but what I'm doing immediately after murdering him. Her plan with the Midway mansion is consistent with her dream of living there with Josh Grossman, running it as an event center, farming, and raising Eric's kids. Her plan to sell the home she lived in proves that she had no idea that home was in a trust.
Right.
She couldn't sell it. Her
Right.
plan on running Eric Richins' half of C&E shows that she did not understand the buy-sell agreement, the life insurance coverage on the buy-sell agreement, or that life insurance coverage went to the trust, not her.
Right.
The morning Eric died, she had a plan on how she was spending Eric's money and didn't realize it was trust money. We know that Kouri Richins intended to kill Eric. The evidence proves that she intended to kill Eric, in part based on her conversation with Josh Grossman shortly after killing Eric. Kouri Richins asked Josh if he had ever killed anybody. Killed was her word. Not have you ever lost a loved one? How do you agree? Not have you ever walked in and found a dead body unexpectedly? Not how do you respond to a tragic and horrible accident? It is how you have you killed. And then she asked how it made him feel. She asked that because she was working through her own feelings on killing and wanted Josh to help her work through those feelings.
Mm.
And never mind that that's a highly selfish question. She's worried about working through her feelings on killing. Never mind Josh Grossman's feelings on having had to have killed in service of his country. It was her feelings that mattered.
Oh, darling.
Walk the dog ladder.
Mm-hmm.
There's a lot to unpack in this, But right now, let's unpack the fact that Kouri Richins says Eric gets pain pills and fentanyl from Mexico. She goes on to talk and says, Eric finally told me and asked if Carmen could get him some pain pills and fentanyl from Mexico. Some refers back to pain pills in Mexico from fentanyl. Sorry, pain pills and fentanyl from Mexico. Kouri Richins knows 4 months after she's been arrested for Eric Richins' murder, a year and a half after she murdered him, she knows that she bought fentanyl and she has to explain it. And how does she explain it? A year and a half after murdering Eric Richins, she blames it on Eric. Oh, I bought it for Eric. That's the sum of the evidence. Her self-serving statement asking her brother to testify falsely that she brought it from Eric, for Eric. Year and a half after she murdered him. Kouri Richins did not tell the 911 dispatcher, hey, I just bought some fentanyl for Eric. She didn't tell the paramedics, he might be dying from the fentanyl I just bought for him. He didn't tell the deputies that responded. He didn't tell Detective Woody. He didn't tell Dr. Ulmer. Didn't tell Christensen. Didn't tell her friends. Didn't tell her family. All the off-ramps she had to, the opportunity to take to say, hey, I bought the fentanyl for Eric. She doesn't, because it did not happen. She did not concoct this story until a year and a half after she killed him. And it is a story. It's a fake story that she wants her brother to testify to. There are, of course, other inaccuracies. Kouri Richins in the Orange Notebook writes, self-servingly, when the EMT walked up to me and said he didn't make it, we did all we could, I lost it, I immediately ran to the bathroom. This is the video of when the EMT walked up to her.
Right.
She said when went to bed at 9:30. She slept with the kids because then she goes to bed. She went to bed. So around 3 o'clock, moved into her bed.
We'll stop it there. We could play it for several more minutes. She doesn't immediately or otherwise run to the bathroom and throw up. When people make up stories, they are inconsistent in the retelling.
True.
Here in the Orange Notebook, Kouri Richins says they make the Moscow Mule and the lemon drop shot in the kitchen, and then they go to bed and brush their teeth. Here, they drink it in the bedroom, not the kitchen. Kouri Richins tells her attorney, it's on the right, she tells her attorney that Eric was on the phone when she went into Ashton's bedroom. But Eric Richins' phone activity tells a different story. Kouri Richins repeatedly said that she went into Ashton's bedroom 9:30, 9:45. Eric was off the phone before 9. In the orange notebook, Kouri Richins says that Eric was awake when she went into Ashton's room. And that rambling phone call with Bryce Knutson that Chelsea Barney recorded, she suggests that he was asleep because she says when she returned to the bedroom about 3 a.m., Eric was in the exact same position as he was when he fell asleep. That means she was there when he fell asleep, not in Ashton's room. Her story is inconsistent in the details. That proves that much of it is fake.
Interesting.
We've read text messages throughout this presentation. We'll continue to publish some more for you to read. None of those text messages were recovered from Kouri Richins' phone. They
Right.
were recovered from Eric's phone, Chelsea Barney's phone, Josh Grossman's phone, but not Kouri Richins' phone
Right.
because they were deleted. That is part of her cover-up. When comparing the contents of the phone with few to no text messages, with the contents of the call detail records, with thousands of text messages, that's how we know they were deleted. When Detective Woody executed the first of the search warrants on April the 13th, 2022, and she informed Kouri Richins that toxicology showed that Eric died of fentanyl poisoning, Detective Woody seized her phone. On her phone that she got to replace the seized phone, on the phone that Kouri Richins got to replace the seized phone, these are the searches. What was Kouri Richins worried about? She was worried about the police recovering all her deleted text messages. Why? They're inculpable.
Consciousness of guilt.
They would further prove that Kouri Richins bought drugs from Carmen Lauber to then murder Eric Richins.
Oh, darling.
Her phone searches reveal what she was thinking. She's worried about being investigated.
Right.
She's worried about having to take a lie detector test. She's worried about my office. She's worried about her seized electronics. Prison is on her mind. So is money. She's interested in the life insurance. We don't know precisely when these searches were conducted. It's just not in the digital data. We have the data we have. But we do know that she hasn't been paid out yet on life insurance. She started getting paid out in June of 2022. And this phone she got in April of 2022. So the inference is that these searches occurred between April and June of 2022. This one's the most insightful. If someone is poisoned, what does it go down on the death certificate as? She didn't search if someone accidentally ODs.
Right.
She doesn't search if somebody is dead for unknown reasons.
Right.
She searches if somebody is poisoned, because that is what happened.
See, I told you, like, your words matter, right? And she's writing all of these things. She's texting all of these things. She's searching for all of these things. You put it all together. Oh, she like basically told on herself.
Now we have to prove that Kouri Richins intended to murder Eric Richins, which means we have to prove that Eric Richins did not commit suicide. Kouri herself says he didn't, no mental health concerns. But the other evidence proves it as well. Eric had every reason to live, the first three of which are Carter, Ashton, and Weston. He was a phenomenal father. He protected his boys. He put his money in trust mostly for the benefit of them, to protect them. He was a protector. He's not leaving his boys. He was also planning for the future. He was a successful business person, and he and Cody had future business plans. He had future plans with his sister. They were planning family vacation to Disneyland. He was planning on buying a cabin in the Uintas with his father for the family. Every shred of evidence in this case proves that Eric did not commit suicide. This wasn't an accidental overdose. Eric Richins did not use drugs. He did not use illicit drugs. Set aside THC gummies. Kouri Richins said, no, never. The deputy went in paramedic outfit. These are people that it would have made sense to tell he used illicit drugs to in the moment as paramedic outfits trying to save Eric's life. But no, she was honest. Nope, never. Same thing with Dr. Ulmer as they're reviewing the toxicology and trying to explain the fentanyl, right? Dr. Ulmer's like, well, there's this fentanyl, really can't explain it. Did he do illicit drugs? No, never. Grossman, she's honest with anybody. She's honest with Grossman. No, Eric did not use drugs. Her best friend, another person she's honest with. Nope. Life insurance company? No. Chief medical examiner? No. And every bit of evidence that came into this case, everyone who testified and knew Eric well, his friends, his family, no, Eric didn't use illicit drugs, not even prescription drugs. Your Honor, this might be a good place to take a break.
Let's do it. Folks, one moment, just a friendly reminder. Don't talk about the case. Don't allow anybody to talk to you about it. Do not do anything with your devices during this break related to this case at all. We'll return at 10:20. Please rise for the jury. Court's in recess until 10:20. Thank you.
Okay, we have a Zoom room, so we are not going to stop. We are going to go forward.
Thank you, Your Honor. Recall at the outset of closing when we were looking at the aggravated murder charge. I mentioned the first two elements are murder, and then we get into the two aggravators. So the closing up until now has been the murder charge. That is straight murder. But the state, of course, has charged aggravated murder. So now we'll talk about the two aggravators. The why aggravator, money motive, and the how aggravator, administering any substance in a lethal amount. You'll recall Brooke Carrington's testimony. And when she began her forensic accounting analysis, this drew her attention. The number of overdraft and non-sufficient funds transactions beginning in April. That jumped from 1 in September to 37 in October, beginning in October. That jumped from 1 in September to 37 in October to 77 in December. And Brooke Carrington's analysis was the beginning of the downward financial death spiral. Then Ms. Carrington analyzed the overall debt, and it showed a growing debt picture nearing $8 million in debt when Kouri Richins closed on the Midway Mansion. All the while, she's not paying it off. She's barely sending her creditors any money. And it's never an increasing amount of money, it's flat. The payday loans particularly showed distress to Ms. Carrington. This isn't a traditional mortgage. This isn't even hard money lending. This is, give me money today, I'll give you money when you get paid at an extraordinary, exorbitant interest rate.
Right.
And when Brooke Carrington solved this, she sees the line here go flat. Payday lenders would no longer lend to Kouri Richins. She was barely paying them off, or barely paying towards them. Kouri Richins lost money flipping homes. You heard Brooke Carrington testify about the extraordinary growth and unsustainable level of growth for even sophisticated business people. Kouri Richins is not a sophisticated business person. She didn't even understand fundamental accounting, fundamental tax reporting.
They're
Brooke
dogging
Carrington
her,
plotted out
man.
the profitability analysis of each of Kouri Richins' home flips. Kouri Richins, when she bought a home, when you total up the home she bought and the loan she took out, she started her projects $2 million in the hole.
Yeah, that's not good.
When she was finished her projects, of money that Brooke could trace to expenses, she
Right.
could only trace about half of it to expenses because Kouri Richins did not conduct normal accounting.
Right.
Kouri Richins lost $469,000 on her home flips. But recall that Brooke Carrington testifies there's this other pot out there of $400,000 that I know she lost. I just can't trace it to a particular project.
Right. Uncountable money.
When you add those up, it's nearly $900,000 loss in flipping homes alone. Recall that Brooke Carrington said that does not count the foreclosures. While
Right.
deliberating, you'll have this, and on the second page, you'll see all the foreclosures. She lost millions more in foreclosures. To include foreclosures on Chelsea Barney's home and the
Yep.
Midway Mansion.
Yep.
Kouri Richins would borrow money by any means necessary.
Yep.
6 times she submitted inaccurate bank statements to lenders to get money.
Yep.
Those bank statements reflected her business account and balances in C&E's business account.
Right.
This evidence proves the level of financial desperation that Kouri Richins was in late 2021 and early 2022. The next level of financial desperation is taking $45,000 of your best friend's hard-earned cash tips from waitressing, telling her that you are going to apply that as a down payment to a mortgage on her house where she lives with their partner and her children,
Yep.
and then diverting part of it to pay off Fund 5 Merchant, a payday lender,
Yep.
and spending the remainder of it, as Brooke Carrington testified, on expenses to rehabilitate homes and servicing existing debt.
Oh
Then-
boy.
Telling your friend, your best friend, since middle school, that you applied the money to the loan, here's the deed, sign the deed, and then not filing it.
Yep.
You will see, if you review that Brooke Carrington's schedule that had all the property transactions, you'll see that not only did Kouri Richins not file the deed, she took out another loan on the
Right.
house.
Right.
That's the loan that was foreclosed on, that resulted in Chelsea Barney, her partner, and their children getting evicted and losing their life savings. That is the next level of financial desperation that Kouri Richins was in January 2022. There's the tax liabilities. In the grand scheme of the amount of debt, 150 grand in tax liabilities is de minimis, but they were on her mind. There's an interesting little nugget here. She underreported her expenses in flipping homes to her tax account, which resulted in her paying more taxes than she would have. One would think a sophisticated business person would think to limit their tax liability. That's not what interested Kouri Richins. What interested her was the appearance of success in business, the appearance of affluence. And by underreporting her expenses, it looks like she made more money than she did, and she appeared more successful than she was. Because she cared not about being successful, she cared about her facade. She cared about appearing successful.
Wow.
You'll recall that C&E distributed $36,000 to pay some of this $150,000 tax liability, which Kouri Richins then diverted to close on a home. And her tax liability was on her mind. 2 days before murdering Eric Richins, she spent over an hour and a half on the phone with the IRS. It was on her mind because if the IRS moved on her tax liabilities, Eric would find out. She had to fix it with the IRS before Eric found out. You're familiar. Kouri Richins needed cash immediately when she murdered Eric. Eric's long-term earning potential, immaterial. She wanted to close on the Midway mansion. She had no money to refurbish it, to flip it right away, to run it as an event center. But she was going to close.
She had no money to buy it. How did she even finagle that is beyond me.
On it. She needed money now. Doesn't matter if Eric's going to earn a ton of money down the road. That does not help her now with the Midway mansion. It does not help her now with servicing her existing debt. She needs money now because she's closing on the Midway mansion on March the 4th. And when she closes on the Midway mansion, it's worth $2.9 million. She's borrowing $3.2 million. None of it's her money. She's reaching
Right.
into other people's pockets to get that money.
Right.
Not only does she want money to purchase the Midway mansion, she wants $87,000 for herself. She takes out $87,000 at closing. And how does she spend it? Servicing existing debt and expenses for rehabs. She ultimately closed on the Midway mansion the day after she murdered Eric. There's an interesting thought here. Did she close on the Midway mansion in spite of murdering Eric? Or did she close on it because she murdered Eric? She hedged. She was supposed to close on the 4th. She didn't want to close until she knew Eric Richins was dead, because she knew she would have his money. She knew she could do something with the mansion. And that's why when everybody else signed on the 4th, or in advance of the 4th, she signed on the 5th. It's unconscionable that she closed in spite of his death. It's unconscionable that she closed because of his death. This is probably Kouri Richins' true plan for the Midway mansion. And if Eric had not put most of his assets into trust, it could have happened. Recall Brooke Harrington's testimony that after closing on the Midway mansion, Kouri Richins' liabilities were right about $8 million, and she was in the hole $1.6 million. Her net
Right.
worth was negative $1.6 million when she
Right.
murdered Eric. That her business was in financial distress, her financial enterprise was collapsing, had been collapsing, and but for a significant infusion of cash and capital would continue to collapse. That significant infusion of cash and capital was supposed to be Eric Richins' money. You have a fortunate perspective during this case in that you get to observe the defendant. You get to observe Kouri Richins. And you observe her affect with some, when some witnesses testify, and you observe her affect change when other witnesses testify. You observe that when we played the 911 call during trial, her affect was flat, no emotion. You also observe that when Brooke Harrington testified about the financial distress of her business, she was exercised because that testimony pierced her facade. It pierced her facade of being a successful, privileged, and affluent person. It was a narcissistic injury.
Oh my, can you, Mr. Bloodworth, can you say the law nerds? You are watching the law nerds, right? Because how many times did we clock her facial expressions and post it, right? And they were exactly at these moments. I could go back and show you, but he is watching. They're watching.
She was bothered because the world saw that she is indeed not a success and not affluent. The bulk of Eric Richins' estate was in insurance coverage. Some of it got paid out to the trust, some of it got paid out to Kouri Richins. Kouri Richins knew this, knew that much of his estate was insurance coverage. And different than taking money from Eric's home equity, different than taking money from Eric's bank account, to take Eric's insurance money, Eric has to die. Now for the aggravator of administration of any substance.
But not only that, when she took the insurance money, she put the insurance money towards her debts and stuff, right? Instead of being, I mean, what a normal person do? Sorry, her not her personal debts, her business debts. That's where she took the money and she put it into that. She didn't put it into her own personal accounts for her and her kids.
Any substance in a lethal amount. The substance here happened to have been fentanyl, could have been any part of the illicit street drug that she bought, happened to be fentanyl that she administered in a Moscow Mule and a shot or a shot. But we know that's how she administered it because it was in his belly.
A boatload.
We know it was a lethal amount. The death certificate, fentanyl killed him. That's the substance, lethal amount. Can be as small as 3 nanograms per milliliter. And in this case, he had 15. 5 times what can be a lethal amount. That, by the way, is not an accident. That amount of fentanyl shows that Kouri Richins wanted Eric not only dead, but good and dead.
Good and dead. Wow.
Now, count 2, the aggravated murder. The elements are the same as count 1. The only difference is attempt. Attempt requires, as the court instructed, a substantial step. There's plenty of substantial steps from ordering the drugs to making the Moscow Mule.
The attempt.
Here, the aggravated murder count proves the attempted aggravated murder count and vice versa. The commonalities between Kouri Richins' conduct are not coincidental. In each instance, she purchased drugs from Carmen Lauber a few days out. In each instance,
Hang on, I'm gonna I want to screenshot this, but everything else is in the way.
Dental. In each instance, she purchased drugs from Carmen Lauber a few days out. In each instance, she spoke with the IRS a few days out. Taxes were on her mind. Eric would find out if the IRS was after them. In each case, she had an immediate financial stressor. We just discussed closing on the Midway Mansion. If you look at Brooke Harrington's materials, she had a note due on Chelsea Barney's house shortly before February the 14th. She had an immediate financial stressor in each instance. In each instance, she administered the substance in a way that Eric would ingest it. On Valentine's Day, it was a sandwich. When she murdered him, it was a drink. Notice that she learned from her mistake. One can season a sandwich with fentanyl. Eric can eat it, tell something's wrong, set the fentanyl-laced sandwich aside. You throw a lemon drop shot back. By the time Eric would notice, the shot was in. It was in his body. Moscow Mule, just to be good and sure. In each case, she leaves Eric alone. She distances herself from the dirty deed. She leaves the bedroom when she murders him. She leaves the county when she attempts to murder him. As part of her alibi. Not only can she not be present, she has to be distant. So that when she calls 911, she says, I wasn't even there. I was in Utah County. And in each case, she has a delayed response, right? It's the delayed response in calling 911 when she murders him. And it's her delayed response in returning home when she failed to murder him. The element of, again, is it Kouri Richins? Yes. She is the person with the means, the motive, and the opportunity. Nobody else. The means, illicit street drugs in the sandwich. The motive, money, fresh start at life. The opportunity, she left the sandwich in Eric's car. Intentionally or knowingly caused the death of Eric Richins, right? It's attempt, so attempted to cause the death of Eric Richins. The same reasons. She told Becky Lloyd it would be better if he were dead. She wanted the Michael Jackson stuff, the lethal stuff, the fatal stuff, the stuff that kills. She wanted Eric Richins' life insurance. You only get life insurance when Eric's dead.
You only get life insurance when somebody dies.
The commonalities persist. Kouri Richins ordered fentanyl from Carmen Lauber, or ordered something from Carmen Lauber, the Michael Jackson stuff, the fatal stuff. Carmen says, I told her I could get her fentanyl. She said, okay, get the fentanyl. But she ordered illicit street drugs from Carmen Lauber, who got them from Robert Crozier at the Maverick in Draper. Again, the volume of calls during the drug purchase between both Kouri Richins and Carmen Lauber and Robert Crozier and Carmen Lauber. And recall, we don't have the content of the texts because they were deleted from Kouri Richins' phone, deleted from Carmen Lauber's phone, and Crozier lost his phone. The IRS was on her mind. She called him twice, 3 days before attempting to murder Eric Richins. We know she placed the call to the Mirror Lake Diner to order a potentially fatal sandwich. We know that Kouri ordered it. Kouri picked it up in person. It was swiped. Don't know if you can tell that's Kouri Richins' signature, but notice it's one stroke. There's no pen lift. We'll talk more about that in a minute. Kouri Richins then distanced herself. She left the sandwich for Eric, and she drove an hour away to meet up with Josh Grossman on Valentine's Day. There's another commonality between the attempted murder and the murder, of course. They're big days. Losing your husband on Valentine's Day, that garners extra sympathy. extra attention. Losing your husband the same day you're supposed to close on the biggest purchase of your life, that garners extra attention. The type of attention that Kouri Richins relishes in.
Get with the
You've
faces.
heard Kouri Richins testify how Eric was a cowboy when it came to injury or illness. He worked through it all. He cowboyed up. Cowboys don't go to the hospital unless they're near death. They don't even think about going to the hospital unless they're near death. And at 11:33, Eric's thinking about going to the hospital. And then all the activity, the physical activity on his phone ceases for 87 minutes in the middle of a busy workday. Shortly after activity resumes in Eric's phone, he calls his best friend and business partner Kouri Wright. Recall Kouri said he could hear the fear in Eric's voice, a fear he'd only heard twice before, both times associated with death. A fear he heard when Eric told him his mother had passed away, and a fear he heard when someone who struck Eric's truck in an automobile accident, and Eric thought that person might have passed away. He then spoke with his hunting buddy and close friend, Josh Kays. You know and learn a lot about somebody when you hunt together and travel together. And Josh Kays said, Eric sounded somber and serious. Josh asked Eric perhaps the two most pertinent questions: if he was going to the hospital, and what was he going to do about it? Let's turn to alley staking, singular, not plural. Clearly, close with Kouri. Friends since middle school. You observed the banter when Ms. Staking was testifying, the banter between her and Kouri Richins. It was friendly. She's still friendly with her. And Allie Staking testified about how a week or two after Valentine's Day, when Kouri Richins attempted to murder Eric, when I questioned her, she said, well, Eric jokingly, kind of jokingly, maybe jokingly said that Kouri Richins tried to poison me. Perhaps joking. But Kouri Richins' reaction is what was important here. Kouri said, no, she got defensive. That is not what happened. It was like an allergic reaction or something. It wasn't at all dramatic. She is covering up for poisoning him. Then when defense counsel questioned Ms. Staking kind of backed off the jokiness of Eric's comment and attributed the jokiness to everyone else. Allie Staking said, well, defense counsel questioned, what did he tell you? That he believed Kouri had tried to poison him. Maybe it was one of those joking things like, I'm sending a message to Kouri Richins. I know what you tried to do. I'm joking about it, but I'm going to let you know. Maybe he was serious. Either way, it comes back to Kouri Richins trying to poison him on Valentine's Day. Kouri Richins repeatedly tries to cover up that she tried to murder Eric on Valentine's Day. She says she was home with him. She tells her best friend, Chelsea Barney, I was home with him. She was not. She was with Josh Grossman. She did not come home until after 6:30 p.m. She was saying he never broke out in hives or used an EpiPen. That means he broke out in hives and used an EpiPen. When she spoke with her mother on August the 22nd, when she says she didn't put a love note and the sandwich in the front seat of his truck, she put a love note and the sandwich in the front seat of his truck. She is trying to distance herself. She is trying to cover up. She is trying to deflect.
Oh, that's Sky
Eric said
Lazaro,
he was
her
going,
former
thinking about heading
attorney.
to the hospital.
Wow.
What did she say? Take a nap. Call me when you're up.
Just go take a nap.
She's saying that thinking he will take a nap and not wake up. When he does, Eric texts Kouri. He's asking if she's home because he had just said, I'm going to hospital. Then he had stopped communicating, or he said, I'm thinking about going to the hospital, and then stopped communicating for nearly 2 hours.
Right. She texted him anytime during that
He's figuring
period?
she was coming home to assist him, but she wasn't. She's in Provo waiting for a cabinet installer guy. Maybe. She says then she's going to head home in 20 minutes. Nearly 2 hours later, question mark, where are you? You were heading home 20 minutes ago. She responds, what? Thanks for answering. Did you call? You didn't call. She thinks he's heading home. She's not. She's trying to figure out what to do. She's trying to figure out what to do because Eric survived. She had not planned on that. She is delaying to make her plan. And then at 6:34, Eric texts, we're headed in there. Food is on the front seat of his truck. The same place she left the poisoned sandwich with the love note. Eric Richins is telling her, I know what you did. That is the attempted aggravated murder. That is the attempted
It's
murder.
a little
Now,
bit of a
of course, we have the
stretch,
two
but
aggravators. They're the same. Same
who
as the
knows?
aggravated murder. The money motive, same. Similar financial distress, same. There's also the fresh start at life motive, right? That hasn't changed a bit. Josh Grossman, it's Josh Grossman on Valentine's Day, and he's Josh Grossman on March the 4th. Money motive the same, fresh start at life motive the same. Now the second aggravator, administration of any substance in a lethal amount. Recall Dr. Eric Christensen's testimony that hives, EpiPen, all consistent with an opiate-like or an opiate allergic-like response, a pseudo-allergic response. Hives, EpiPen, along with zero activity, shows that Kouri Richins attempted to administer the illicit street drugs that she bought 3 days earlier from Carmen Lauber in a lethal amount. She just failed. That's got it. Okay, the insurance fraud. There are two insurance frauds. Let me distinguish them, please, for you. The first one is a scheme charge, a fraud scheme. The second one is a fraud claim charge. Count 3, the scheme charge relates to the $100,000 true stage policy. We're going to put it up in a minute. The fraud claim charge relates to the $250,000 true stage policy. The forgery, which we will get to, is a forgery related to count 3, the scheme charge. Let me unpack them now. Okay. Different than the aggravated murder and attempted aggravated murder, I'll address all elements of the insurance fraud scheme kind of at once because they all jump out of this single page. And the scheme is quite simple. Kouri Richins wanted to murder Eric Richins, and the scheme is quite simple. Kouri Richins wanted to murder Eric Richins, thus took out an insurance policy on his life to get money for murdering Eric Richins. Then she murdered Eric Richins, and then she submitted a claim to get the money. That is the scheme. And we know it was Kouri Richins because everything on this application for this $100,000 true stage insurance policy returns to Kouri Richins. Kouri Richins received the application, because she was a member of PedFed, the application was addressed to her at her work address. So she would have been the one who received it. If there was any questions about it, any further follow-up mailings about it, they would go to her and not to Eric. This applicant information is all her, but the partner information is all her as well. Her work address, no email address where they could contact Eric. We'll get to the social security number in a minute. The primary phone, that's not Eric's phone. You'll see that Eric's phone is 801-792-9317. And when you look at this closely during deliberations, you'll see that was originally a 7 that she later marked up to read like an 8. She initially wrote his correct phone number, then did not want anyone from True States to call him, so she changed the 7 to an 8. So that Eric would never know that this policy existed. After Kouri Richins took $250,000 out of Eric's home equity, he put all of his insurance that he knew about into the trust. If Eric had filled this out, the beneficiary would have been the trust, not Kouri Richins. Then we'll get to the signature. That's the fraud count 5 as well. It plays into this. We'll talk to it during count 3, but it's also the freestanding charge in count 5. Let's go to the next page. The social security number was blacked out for privacy reasons on the application we just reviewed, but you'll recall Ann Coates testifying that the last 6 digits were transposed. We all know our own social security numbers. We often get a little bit confused on our spouses. Eric did not sign the application. Matt Throckmorton, the handwriting expert. Eric did not sign it. It was probably a simulated forgery. Recall his testimony that Eric Richins has pen lifts in his signature. The forged one didn't have any pen lifts. You'll see Kouri Richins' signature throughout this case. No pen lifts. Then Kouri Richins filed a claim for this $100,000 True Stage policy. It's actually the same claim for both policies. And she said she really does not know where her husband Eric got the fentanyl from. Of course she knows. She ordered it from Carmen Lauber. That is the fraud scheme. Plan to kill Eric, fill out life insurance so I can get money for killing Eric, kill Eric, and then claim the money. Now for the insurance fraud claim count 4. This is the True Stage $250,000 policy. This is the claimant's statement filled out. Kouri Richins beneficiary, Kouri Richins email, Kouri Richins address. Everything about this claim says Kouri Richins is submitting this claim. And then, like before, the fraud here, the falseness of it is she says she doesn't know where the fentanyl came from, when in fact she ordered illicit street drugs from Carmen Lauber. And indeed, later in the Walk the Dog letter, admits to asking Carmen for fentanyl. Finally, count 5, the forgery charge. We've discussed most of the forgery when we discussed count 3, but there's this without the authority to do so element. It's not a forgery if Eric gave Kouri Richins permission. The state has to prove that Kouri Richins did not sign Eric's name with permission, with authority. All of the evidence in this case proves that Kouri Richins does not ask for permission, she takes. She took with the
Okay, that's what I was wondering. How are they going to state that she didn't that she didn't get permission to do it? But whoa, that's big.
home equity loan. She took other people's money. She's a taker, not an asker. Finally, like I mentioned earlier, Eric Richins, the evidence proves, would have put the trust as the beneficiary, not Kouri Richins. If he had given permission, it would have been permission to make the trust the beneficiary. That's the forgery.
Interesting.
Let's please now turn to Kouri's motive for a fresh start at life. You heard the instructions. The state does not have to prove any motive except for the pecuniary gain motive because it's an aggravator.
But let's just
But
go
motive
ahead and
explains why Kouri murdered Eric Richins, why she attempted to murder him. Motive explains
listen. We have some more evidence, and we just can't help ourselves. We're going to tell you what it is.
a lot here. These texts at this point are familiar. The day after.
Well, I'm married. You, me, our relationship. I don't know what else to call it. I'm in love with you. Love with a man that's not my husband.
Kouri Richins speaks with Becky Lloyd and tells Becky Lloyd she would be better if Eric were dead. She texts Josh Grossman that she's in love with him, a man not her husband. If I was divorced right now and asked you to marry me, would you? That's the day after the attempted murder. If he could just go away, and you could just be here, life would be so perfect. We're familiar with this text. We've read it already today. I ask you to read it again. This time, replace the word divorce with the word murder.
Oh, whoa. Whoa. Oh, shoot. Oh, my goodness gracious. Oh, I want to. All right, I hear you. Okay, here we go. Oh, boy.
This graphic shows a juxtaposition between Josh and Eric that is insightful to what Kouri thinks about each of them. In each instance, she is texting, well, she is kind of simultaneously texting. These are laid out chronologically. She is simultaneously texting with both Josh and Eric about closing on the Midway mansion. And she is so excited texting with Josh. I can't believe it. I want to celebrate with you. Love you, love you, love you. Thank you for always being my support, shoulder, and rock. I need you all the time. Some things I could never do without your encouragement. You have no idea how much I appreciate you. Eric tries to reach out. You want a shot? Can't. Sorry, busy. Then right back to Josh Grossman. To me, you're worth millions a year. I'm honored to be your best friend, your lover, your go-to. Life is going to be different, I promise. You're one hell of a patient person. I hate your hard days. I wish I could be there to turn them around for you. Can I try Friday? Give me a few days. Hang in there until then, please. By Friday, of course, Eric Richins was dead. Kouri had murdered him. She's right. Life's going to be different. She promised him. It was. Then, 16 days after Kouri Richins murdered Eric, are we there yet? And then 1 month later, Kouri's ready for Josh to be her husband. Josh Grossman loved Kouri Richins. He believed that she loved him. Not sure that's true. You saw him testify. He was gutted. As a grown-ass man gutted. You also observed Kouri Richins' affect when he testified. Flat.
She wasn't completely flat. She was emotional, like she wanted to reach out to him. Hang out, sneeze.
The evidence proves
She was flat a lot of times.
that Kouri Richins murdered, attempted to murder Eric Richins, and that she committed 2 counts of insurance fraud, Eric Richins, and that she committed 2 counts of insurance fraud and forgery. The evidence does not support any other rational explanation. The state, since its opening statement, has stressed the requirement to consider the evidence that has been admitted and not what the attorneys say. What the attorneys say, insinuate, speculate is not evidence. Please let me show you why the state has stressed this. In the defense's opening statement, counsel said that the evidence will show that Kouri Richins had a 1/2 interest in the Willow Court home. There is no evidence of that.
Oh, I thought that they were going to do this. I knew that they were going to do this because the defense made a whole bunch of claims in the beginning. And obviously they didn't put on a defense, so there's nothing to claim. Oh, Mr. Bloodworth going for the jugular.
And indeed contrary evidence. Defense counsel said that the evidence would show that Eric was always checking Kouri's phone. There's no evidence of that. Defense counsel said that the evidence will show Eric and Kouri Richins went to marriage counseling. There's no evidence of that. Defense counsel said that the evidence will show in the few weeks before Eric died, his closest friend thought that he and Kouri Richins were the happiest together that the friend had ever seen. There's no evidence of that. Defense counsel said that the night Eric died, he and Kouri Richins had their drinks and set their cups in the sink. There's no evidence.
Well,
Defense counsel said that the evidence will show that the cups were sitting in the sink and the nanny put them in the dishwasher the next morning and they still had fluid in them. There's no evidence. Defense counsel said that Eric talked to a friend named Scott Wagner at 10 p.m. the night he died. There's no evidence of that, and indeed contrary evidence. Defense counsel said that the evidence would show Eric unlocked Kouri Richins' phone at 10:30 p.m. the night he died, and this is the last thing that he did. There's no evidence of that. Defense counsel said that the evidence would show investigators interviewed Kouri over and over and over again about what happened the night that Eric died. There's no evidence of that. Defense counsel said that the evidence would show that law enforcement secretly recorded Kouri Richins' phone conversations for over a year after Eric died. There's no evidence of that, and indeed contrary evidence. Defense counsel said that you will hear Kouri Richins telling her family that she purchased pain pills for Eric at his request. You did not hear that, although she did write it in the Walk the Dog letter 4 months after she was arrested. In listening to defense counsel's closing argument, please only consider the evidence that has been admitted.
Ms. Lewis.
Your Honor, could we address something outside the presence of the jury before
Of
we
course.
start?
Folks, let's give you an opportunity to stretch your legs, use the restroom. Please rise for the jury.
wow, what a mic drop at the end. Only consider evidence that was brought in. You can't consider all of these things. Holy smokes, holy smokes, holy smokes. The prosecution just obliterated the defense. What are they going to say then? Wow. All right. So we're going to stop with the prosecution and then we'll come back and do the defense, only because it just makes it a little bit easier. She could not leave him, but not his money. There was a quote from Deborah Bloom that was really, really good. He had some really, really good statements. The Google search about if someone is poisoned, right? Why? She wanted the money to get the debt. Wanted Eric good as dead, good and dead. Where's the thing about feigning? She's a very ambitious person. He said that several times. She gambled other people's money and that she was incompetent and by any means necessary. Wow. That was very, very interesting. All right, so let me know in the comments what you think about the prosecution's closing statements. Very, very telling, very, very interesting. Wow. Mic drop. Thanks for watching Legalese 123. If you like what you saw, please like and subscribe for more content.